Everybody. Well, my name is Michelle Buspa. I am the Gender Equity Advancement Coordinator at Muslim Women's Organization here in Orlando. And we are super excited and honored to present this Let's Talk About Marriage Workshop Part 3 this evening, which is focusing on divorce. And we have two wonderful presenters tonight, and I'm going to do their bios individually. So I'll tell you more about Gigi in just a minute, but she is here. She'll be presenting in the second portion of our presentation. But first, I want to introduce Amani Shalaby. She is our Hakima coordinator here at MWO, and she is just the most amazing teacher. I can speak from personal experience. But so going on a little bit more of a bio, let's see. She obtained her certificate in clinical pastoral chaplaincy from Advent Health. She earned her postgraduate diploma in Islamic studies from the Islamic College of Advanced Studies in London in 2002. In 2015, Amani earned her master's degree in comparative philosophy of religion from Middlesex University in London. Amani obtained an Ijaza license from Sidi Sheikh Mohammed Saeed Al-Jama, who was the Imam for Al-Masjid Al-Aqsa and the head of the Sufi Council in Jerusalem for 30 years. She served for 12 years as the Sheikh's simultaneous interpreter, and she translated 20 books on Islamic spirituality written by the Sheikh. Sheikh Mohammed Al-Jamal taught that there is only one divine message for humanity. It is the message of unity, love, peace, mercy, justice, and freedom for all. Amani has 18 years of experience providing spiritual care for several Shahadaya Sufi communities across the states. And she's a faculty member teaching Islamic studies at the University of Spiritual Healing and Sufism. She's also serving as a chaplain here at the Muslim Women's Organization. And she is also an author of The Essence of Creation, The Emanation of Consciousness, The Hidden Pearls, and is working on an upcoming book, The 7 Levels of Consciousness. And she's also authored 2 children's books published by Richard Owens Publications, Goa and His Donkey, and The Little Puffer Fish. And she also has 3 children, 2 daughters and a son. So without further ado, I am going to let Amani take it away. She is going to speak to us about the Islamic context of divorce for us. So Amani, please.
Thank you for this long introduction. Alhamdulillah. Assalamu alaikum wa rahmatullah, everyone. I'm gonna just start with Al-Fatiha first. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين صدق الله العظيم. So I'm gonna share like a PowerPoint presentation, and I will send the PDF to Michelle so she can send it to everyone, or to Sadaf, so they can send it to everyone if you want to look again at it. And, you know, Allah subhanahu wa ta'ala says in this ayah, which is number 130, and if they separate, like the couple separate, God will enrich each, or suffices each from his own abundance. So it seems that it gives the permission for divorce, but it's the last resort usually. And people also sometimes say, oh, divorce is something that shake the throne of Allah subhanahu wa ta'ala. You probably heard that before. It shakes the throne of mercy, but the throne of mercy is shaken in people's hearts. Mercy is shaken in people's hearts, and that is the throne of Allah subhanahu wa ta'ala. So when that rahmah is shaking in people's hearts, you can see they try to hurt one another and take more from each other. Or so anyway, I just wanted to mention that in the beginning. So there are several types of divorce in Islam. So the first one is called talaq. It's the divorces that initiated by the husband, and the talaq lid-darar, which means, let me just see so I can keep track of time. Talaq lid-darar is the judicial divorce for harm inflicted on the woman. So if the woman is abused or harmed in any way, she can go to the court and ask for divorce. Then there is the khula, which I translated as, oops, there is an S missing here, ousting, like that is how literally it means. It's a divorce initiated by the wife without any harm, just because she doesn't have a feeling anymore for her husband. And then there is divorce by oath, and we'll talk about that later, because as marriage is documented, divorce should also be documented. As marriage has two witnesses, divorce must have two witnesses as well. We'll talk about the details of each of these cases. So talaq for harm, I'll start with that, which any type of harm, physical abuse, financial abuse, sexual abuse, such as abandonment or rape or cheating or secret marriage that hurts the woman emotionally, and emotional abuse, that is ill treatment, you can say. Those are all mentioned in the Quran and in the Hadith and are ground for divorce. This is not khul. If you experienced or anybody experienced this, it is not considered khul, and that distinction is important when it comes to financial rights. So we know from Ayah 434 that the men or the husbands have the qawama, the financial responsibility towards the women and the children. And if they don't fulfill that obligation or force the woman to spend on the house against her will, for example, then the woman have a ground to ask for divorce because of harm. And then there is the physical harm, of course, is forbidden in Islam, because the Prophet ﷺ has many hadiths that prevent that. He says, refrain from slapping your wife or abusing her, and don't separate from her except in the house, so you will not embarrass her publicly or so. He also said, none but a noble man treats women in good manners, and none but an ignorant man treats women disgracefully. He said, the best of you is the best who are to their wives. He also speak of beating, and he said, don't beat your wife in the morning and expect to sleep with her at night. There is another hadith that says, don't beat the handmaids of Allah subhanahu wa ta'ala, or the creation of Allah subhanahu wa ta'ala. He's known to have never had ever slapped a woman or a child or hurt anybody physically. Of course, there is this ayahs that sometimes referred to as permission to beat someone symbolically, to beat the wife symbolically, but there is other interpretation about that, which means rather than to beat symbolically, it doesn't make sense to me. It means to go and take her to court, to go to marriage therapy, like it's abandonment. It's like abandon her and go for other means to prevent her if she was the abusive one. If the wife is abusing the husband, then the husband will advise her first, then abandon her in the bedroom or inside the house, and finally abandon her totally. So there is no permission, according to Hadith, to hit a woman or abuse her physically. And sexual harm is mentioned also in the Quran, specifically in this ayah. So I'm going to read the ayah. Those who abstain or turn away from their wives must wait for 4 months before divorce is finalized. But if they reconcile, God is forgiving and merciful. If they resolve to divorce, God is hearing and knowing. So according to Muslim jurists, it is forbidden for a man to do so. And the maximum time that a woman can endure kind of or try to reconcile is 4 months. After that, it's ground for divorce. And there are many opinions, but I found the scholars who argue this point are the most in harmony with what the ayah says, that sexual abandonment or abstination or lack of satisfaction, sexual satisfaction. For example, the scholars argued that the husband cannot leave the wife without her attaining orgasm. So all of these, they said, is a ground for divorce. Unless she accepted voluntarily, she's happy like that, that's fine too. But if it is harmful to her, it shouldn't be forced on her, and she has every right to pursue divorce. And sexual violence is also not allowed in Islam. Marital rape is not allowed in Islam. And the scholars in the past has identified rape as coercive in nature. It's a sexual intercourse that is coercive in nature, like violent. But they considered even a threat of a future harm to the wife or to people she loves, such as the children, to use a threat against the wife is considered coercive, and that can be a ground for divorce. So history shows that many Muslim women went to court for this, and not only they were able to obtain divorce, but the courts usually in the past, I am talking, will give them a compensation, like a monetary compensation, like money for the harm they endure. And we find another hadith in which the Prophet ﷺ says 3 things fall under unkindness. And one of them is when a man engages in sexual intercourse without sending a messenger. And people said, what is a messenger? The Prophet said, ﷺ, humor and kisses. So like a foreplay. So nobody should fall upon his wife as a beast. Another hadith that the Prophet ﷺ said. So definitely marital rape is not allowed in Islam, and according to scholars, it's a ground to ask for divorce. Divorce for harm again. So we come across a hadith that circulates in the Muslim community that says if a woman refuses to have sexual intimacy with her husband, she will be cursed by the angels until the morning comes. So first of all, scholars who actually considered the hadith authentic argued that if she has done that without reason, but being tired or sick or emotionally disturbed, is not a refusal. It's a natural condition that women go through. So the Dr. Hebri Karama Institute in Karama Institute, Karama organization, she made a research about the authenticity of this hadith, and she concluded that the narrators did not meet, like, you know how they categorize the hadith. They have to trace every chain of transmission, make sure that the people met in the real life to be transmitting this hadith from one to the other orally. And she found that the narration lacks that authenticity. So the hadith authenticity is questionable. This does not mean that the woman can also use sexuality to abuse their husband in a way that they use it as a tool to, you know, make them bend to their will or things like that. As the Quran says, marriage is about rahmah and love. It's about being merciful and loving. And so it goes without saying that both parties must not abuse one another and so forth. So sexual violence is not allowed in Islam. And now when it comes to khula, which is the third type of divorce, is when the woman initiates the divorce for no reason. She just lost the love in her heart. And that is based on a specific hadith about a woman called Jamila, who was married to one of the Prophet's companion. His name is Thabit ibn Qais. She said to the Prophet ﷺ, by Allah, I have no complaint against my husband. He's a good character. I have no complaint against him, but I dislike to mistreat him because I don't anymore have feeling for him. So the Prophet ﷺ in such case said, have you, had he given you anything as mahr, as dowry or marriage gift? She said, yes, he gave me a garden. So he said, you return to him his garden and then you will be divorced. Unfortunately, that hadith taken out of its context and the context of what the Quran says, some husband abuse it in a way that I'm not gonna divorce you or agree about the divorce, even if it is a divorce for harm, just to make the wife eventually says, okay, I give up all my financial right and I will do khula. So the wife in such a case should not do that, because any Islamic court will be on her side, because it is considered divorce for harm, not khula. Khula if you don't have a complaint against your husband. This is not how it is practiced in Muslim communities or Muslim countries, unfortunately. But if we look at the Quran says, don't let the wife suspended, like not able to marry and not able to pursue a happy marriage with the husband. Don't keep them against their will, another ayah says. So if this ayat says that, then we understand that really khula mean when the wife has no complaint, but she wants to be out of this marriage. At such a case, she will give away her financial rights. That's why it is important to distinguish. Is it divorce for harm or is it divorce without harm? Because if it is divorce for harm, the woman is entitled to all of her financial rights according to Islam. And also if the man initiates the divorce, she's entitled to her financial rights. So in such case, when khul'a happens or the wife initiates it, she abdicates the husband of paying her financial rights, which is the deferred mahr or alimony. And the divorce is final and irreversible. So she doesn't have the opportunity, or he doesn't have the opportunity to return to her again. And the couple cannot reconcile during the waiting period of the iddah. and the husband is required to pay her and support her during the iddah period. That is in all cases of divorce in Islam, that the wife is entitled to financial support during the waiting period, the iddah period. So let us see. So divorce by oath, unfortunately, many people in the United States, they go and they marry verbally in the masjid, and they divorce sometimes also verbally, which leaves the wife without any rights. And in the Muslim countries, it happens as well. But that is not what really Allah says. Allah always says, write every deal, write a contract, have two witnesses. Those two witnesses are not only ceremonial, they should play a role. The wife must have a wali who look after her affair, like a guardian. And now many women, whether converted to Islam or they are alone here without families as immigrants, they don't have a kind of wali and so forth. So I just warn women to be careful to have everything in the marriage contract and not to do things verbally. But this form of divorce happened almost in the past because, or often happened in the past because people didn't have documentation. Now we do have documentation, we have laws, we must follow it. So the first type of oath is called abstinence, which I talked about it in the other slide, that when the man make an oath not to have sexual relation with his wife for 4 months, thinking of divorce or so. That is the maximum he can make, and after that they are divorced. Some scholars say that is forbidden even, because the woman has a right for sexual pleasure, and so she must have that at least, if you count what they said, like twice a week. And then there is the oath of abandonment, complete abandonment, where the husband say to his wife, you're like my mother. I'm not gonna touch you from now on, but I'm not gonna divorce you either. So that is haram in the Islam. And if he wants to return in that oath, he must fast for 2 consecutive months or feed certain number of poor people. And the wife has to also be in agreement that the marriage should continue. So it is not like just up to his whims. And the third type of oath is when a man accuses his wife of infidelity, but he still doesn't want to divorce her. So they go to court, and he makes oath and she makes oath. And if he doesn't still believe her or continue to kind of accuse her of infidelity, but she has already made an oath that she didn't do that, then the judge will divorce them. And the woman is entitled to all of her rights at such a case. And there is another form that happens sometimes in the Muslim community. It is called conditional talaq. It happens when a husband say to the wife, if you go and visit your parents, you will be divorced. Then the wife maybe ends up going. In such a case, should the wife be considered divorced? This is a serious thing, and it causes plenty of problems, plenty of questions to scholars. And that's why most contemporary scholars now say that is not allowed. The husband shouldn't say that. And if it happened, he says it, and then it is not considered divorce. So this is the type of divorce by an oath. And if the man also, I have to mention here, says 3 times that he divorces his wife, he says, I divorce you, I divorce you, I divorce you, they can't return and marry again, because according to the Quran, divorce can take only 2 times, like they divorce and then they reconcile, they divorce again and reconcile. The third time, they can't reconcile unless she marry another man, and then for some reason that marriage also ends, then yes, at that point she can return to the first husband. And so what is the financial divorce of women in Islam? So this financial rights is again for divorced women in the two cases, when the man initiates the divorce and when the wife initiates it for harm, talaq lid-darar. So she's entitled to these 7 things: full payment of any deferred mahr, like you know how Muslims usually do the mahr or the marriage gift, sometimes called dowry. They say, okay, this amount of money or gift will be given immediately, and this other portion will be deferred, will be deferred, delayed for later in case of divorce. But actually, because it is the woman right, at any point during the marriage, she can ask for it. And if the man can afford to give it, he must give it. It continues to be a debt on his side. That is why it is the first thing that the wife is entitled to when divorce takes place. She has to take the delayed mahr. And then she's entitled to child support and to even babysitting salary. And I will show you the ayat about that. And then she's entitled to alimony. I will also show you the ayat about that. And you will read it when you receive the PDF file of this presentation. And the husband, again, is obliged to spend on the woman and during the idda period, the waiting period after divorce. He's entitled to keep the household as it is, to keep the woman in her house and to spend the money that he used to spend when they were married. So that is in the Islamic law also. And then anything that the wife was forced to spend during the marriage, not of her own voluntary will, to support the family, she can actually ask for that too, according to Islam and the Islamic jurists, because the man's responsibility is to spend on the wife and the children. And if he doesn't that and force her to spend while he's capable of spending, then she can ask for it in case of divorce. And then finally, she also is entitled to compensation money for any harm inflicted on her. And that is according to Muslim scholars. So the ayah that speaks about, or the ayat, more than one actually, that speaks about how the women are entitled to receive the full mahr that was agreed upon is this ayah. Allah says, how could you take it when you have gone in onto each other and they have taken from you a solemn covenant? In another ayah, Allah says, it is not lawful for you to take back any of your gifts from your wives except when both parties fear that they would be unable to keep the limit ordained by Allah. If you do indeed fear that they would be unable to keep the limits ordained by Allah, there is no blame on either of them if she gives something of her freedom. Like if she says, okay, I don't need this money anymore, that is fine, but she's entitled to that. It's her right. And it's important to also know, even if you had a marriage contract, but the marriage was not consummated, she's entitled to half of that mahr, even if he didn't touch her, but they were spend time even alone in what they call the legal khalwa in Islamic legal terminology. And this is based on this ayah. And if you divorce them before consummating the marriage, but after the fixation of a marriage gift for them, then the half of that gift is due to them, unless they say, no, I don't want it anymore. So that's up to her. And this ayah about the financial support for pregnant women who got divorced or initiated divorce for harm while she's pregnant, the ayah says that she's entitled to that support. And based on that, the Muslim jurist said that she's entitled to child support and babysitting, because that's what the ayah actually says. It says if they are pregnant, spend on them until they give birth. And if they nurse your infant, give them their payment and conduct your relation in amity. And usually the period of the nursing is 2 years, but when we look at the child custody, we will also see how Muslim jurists give women or mothers the full custody on the children until certain age. And while they are having the children, they are entitled for that child support, and which includes housing, clothing, education, medical care, anything that is necessary in life. And there is no number put in the Quran or percentage. So it is up to the judge to decide how much child support, how much babysitting salary that the woman can have, depending on the income and the wealth of the husband. And this even babysitting salary, I know for sure because I am Egyptian, that Egypt law allows it. I don't know about the other Muslim countries. Alimony. Alimony is allowed in Islam. You can see it clearly in this ayah where it says for divorced women, maintenance should be provided. Actually, it's mut'a. The word mut'a, or called nafaqat al-mut'a, is like pleasure, something for their own pleasure, for the women pleasure, because they spend years in this marriage. So they are not going to be destroyed just because they are divorced. They are entitled to live pleasurably, to live well. So the Quran gives the woman alimony, and some scholars, scholars differ. Some of them said it's obligation, wajib. Some say it is recommended. But the ayah actually says it's obligation. That's why you find scholars such as Tabari, a prominent scholar, said that God Almighty reveals the verse to his subjects as a proof that every divorcee, that is a woman divorcee, is entitled to alimony, or called the mut'a in Arabic. And Shafi'i state that mut'a alimony is mandatory for divorced women, with few exceptions. There is always exception if the woman is like having misconduct or things like that. The Hanafi stated that it is mandatory in some cases. Whereas the Maliki rules that it is just recommended. So you see they differ sometimes. Ibn Hazm says alimony is a duty upon every man divorcing his wife, whether he consummated the marriage or not, whether he agreed on a set mahr or not. And the ruler must force the husband to pay it whether he likes it or not. Mut'a is not nullified in the event of the husband revoking the divorce before the end of the waiting period, nor it is nullified by the husband's death or the wife's death. It still goes to her or her heirs after her if she dies. The problem is that sometimes the scholars think of the mut'a as only 3 the idda period, like that the woman is to be giving alimony only for this idda period, the waiting period before she can remarry. However, the Quran really leaves it open, in my humble opinion. And of course, the jurist said every husband, according to his income and wealth, should be obliged to give such financial support or alimony. You find some fatwa, which I included here, from Ibn Taymiyyah and other Muslim scholars, that says that women are entitled to that alimony. And these are the other three that we mentioned earlier, that she's entitled to be supported during the idda period, and if she spends the money during the marriage per force, then she can ask for it at the time of the divorce, and compensation for harm. And this is a fatwa that is very important, that issued by Al-Azhar, or Dar al-Ifta in Egypt, Al-Azhar University, that said, someone asked, I live in the United States and I am divorcing my wife, and according to the law, she might take 50% of my asset. Is that lawful Islamically? And I would like you, when I send the file, to read this fatwa. He says yes. Why? Because she lives in this country, she spends money in this country, she's housed in this country. The country have made a law knowing the condition of living. So that law must apply in the people living in the United States. Nothing un-Islamic for the wife to do that. For the wealth to be divided, people think it's un-Islamic, and women are told it's not Islamic. Actually, if you look at the ayat of the Quran, when it speaks about the alimony, it doesn't set a percentage, or it doesn't set an amount, a specific amount of money. It leaves it open. And when it is left open, it's up to the judge to decide. And the judge decide according to the living condition and the well-being of both husband and wife, and the well-being of the children where they live, not according to a contract maybe that they had in another country for marriage, and then the husband want to give her the deterred mahar, which could be something really small in another currency, and want to say goodbye after that. And that is not according to scholars. According to scholars in universities and Muslim jurists who really studied and who are eligible to give fatwa, religious ruling. So this is the fatwa. And if you look at Muslim countries, not all of them have this fatwa, by the way, but the Moroccan religious scholars have come with a great similar conclusion, that the wife entitled to have a share or divide the wealth accumulated during marriage. And they argue, even if she did housework, she's entitled to that because she have put labor in that marriage, then she's entitled to have half of that wealth in the spirit of justice in Islam. So they actually changed the law, and the law is similar to the law here, as Gigi will explain to us later, inshallah. So there is nothing un-Islamic in doing so, if you reviewed all the points I said and read this PDF file. Then the idda period, let us talk about it a little bit. So the idda period is that the woman cannot remarry unless she have 3 consecutive menstrual cycles. And again, we will not go through why. Most of the time, the why is, it is, in my opinion, from my studies, the man has to also wait these 4 months, because if you base it in the other ayah, that if the man said, I'm going to abstain from approaching my wife and I am contemplating divorce. I'm not feeling love for her anymore. I don't want her. And he's contemplating the idea. He's also told, according to the ayah I put earlier, he's also told by Allah to stay 4 months. So when the woman is divorced, she's also told to wait for 4 months, which is 3 menstrual period in the beginning of the period. So you add the period time and it will come to 4 months. So it seems the 4 months is a common between these two ayat, which for me, it means that this is the waiting period for both of them to finalize the divorce. During that period, there is negotiation, there is family trying to intervene, and if they choose to reconcile, then they can. But after that period, it is considered divorce, and if they want to return, they have to have a new marriage contract, and it is considered as a second marriage. So this is important to understand. For menopause women or for women who don't get their period for some reason, just naturally, or that they removed some organs and they don't get the period. So what is their idda period? It seems to me that the ayah suggesting that menopause women, it's kind of questionable. It's not very clear whether the menopausal woman or the woman who don't have menstruation, if they should also wait 3 months, because this is what the ayah says. It says, as for those of your women who have reached menopause, if you have any doubts, their term shall be 3 months. And also for those who did not menstruate. If you have doubt of what? Doubt whether she's really in menopause or not. But if she's in menopause, it seems she shouldn't have that idda period. But it's kind of can be interpreted both ways. And then for pregnant women, their idda period before they can remarry is until they deliver the baby. And why is that? Because this is important. They are going to have a child together. So they are giving plenty of time to think what they are going to do. And during that, as I said, she must be financially maintained, and also during the nursing time, of course. But after she delivers, then she's free to, if she wants to remarry, and the divorce is finalized. And this is another ayah about the idda. O you who believe, when you marry believing women and then divorce them before you have touched them, no period of idda have you to count in respect of them. So this is speaking about, again, you had a marriage contract, but no intercourse happened, no consummation of marriage did not happen, then there is no idda. Only when the intercourse occurs, and according to some scholars, when you stay time alone, even if you haven't touched it, then there is this idda period, and the financial support also in each case must be applied. Children custody, as I said earlier, they are giving to the mother, especially if they are in young age, based on a hadith in which a woman came and said, "O Messenger of Allah, this is my son, my womb was a vessel for him, my breasts were a source of drink for him, my lap was a place for him to curl up. Now his father has divorced me and he wishes to take him from me." And so the Prophet said, you have a greater right to him so long as you don't remarry. Does this mean automatically that if she remarries, the children go to the father? The scholars say yes, but mostly they are male scholars who came with that interpretation. But the Prophet said, oh, until you remarry, you have the children until you marry, and then they will go to the father. He didn't say they will go to the father, because when she gets married, the whole assessment, a new assessment should happen at that time, and the judge should look at it, which is best for the children. So that is in my understanding. And what happens, and to what age should the mother keep the children in her custody? It depends. Scholars differ. Some say for boys, early enough, before like a preteen or teen age, they should go to the father. Some says earlier than that, some say later than that. For girls, it differs. They say they better stay with the mother longer, but they all differ. It's their opinions. There is nothing cut clear in Hadith or Quran that put an age limit to that. So it is left to their agreement together, the couple, and also to the judge and to the mediators who will mediate between them. And in some Muslim countries, the law is if the mother cannot take care of the children or dies, the children go to the maternal grandmother or maternal aunt before they go to the father. Fathers now complain about that law and they try to challenge it, because it was seen in the past that women are better taker for the children and giving more of a custody right. And that's it. So I tried to say it quickly. I hope I didn't take much time than I should. I probably did, but alhamdulillah, thank you.
Alhamdulillah. Thank you so much, Amani. That was very wonderful, informative information. And if anybody has any questions, we're going to do question and answer for both of our presenters at the end. So if you have anything for Amani, go ahead and write it down or keep it in your mind, and we'll have time for that soon, inshallah. Something I did want to let you ladies, and I don't think we have any gentlemen present, but let everybody know is that this is all being made possible today by a grant from Islamic Relief. So I just wanted to express gratitude for them to make this all possible. So alhamdulillah. And next up, we have Gigi Al-Khatib. And she is a family law attorney, marriage and family attorney. Sorry, I'm getting all turned around here. So she graduated cum laude from the University of Florida and attained her Juris Doctor from Florida A&M University College of Law here in Orlando, Florida. In addition, she graduated from American University Washington College of Law in Washington, D.C. with a Master's of Law in Law and Government with a concentration in civil and constitutional rights and specialization in gender and the law. So she's practiced family law and immigration law globally and nationally since April of 2013. She is admitted to practice in the state of Florida and federal court before the United States District Court for the Middle and Southern District of Florida. She's fluent in Arabic and conversational in American Sign Language. She is the child of immigrant parents who embedded hard work and community service in her. And she became an attorney to help persons in vulnerable situations. She has almost a decade of legal experience in both the private and public sectors, and she is compassionate and fights for the rights of all of her clients. So she is here with us because she believes in community outreach and advocating on behalf of those who are unable to do so on their own. She has served as a guardian ad litem with the Legal Aid Society of Orange County and attorney ad litem in Miami-Dade County for several years, representing children who have been abused or neglected. She's also served as a legal advisor for the Domestic Violence Committee of Arab American Community Center of Florida. So she is here with us, giving us her time, alhamdulillah. So without further ado, I'm going to turn it over to you, Gigi. Thank you so much.
Thank you. Thank you, Michelle and Sadaf and MWO for having me here today. It's a pleasure. Amani, I love Amani. I know she works a lot within our community and gives back. I'm going to do more of a conversational aspect. Unfortunately, I have similar dialogue several times a day, every week, when it comes to divorce in Florida. As Michelle stated, I do practice family law and divorce. So I do child custody, I do prenuptial agreements, I do modification and dissolution of marriages with or without children and with or without property. I will be starting, discussing the actual procedure of divorce within the state of Florida. And we'll go through that, and then I'll start discussing common issues that I see in particular within the Muslim community. In the state of Florida, and unlike, Islamic law with when Imani was explaining, we're a no-fault state, okay? So meaning in the state of Florida, just as you have the right to get married here, you have the absolute right to file for divorce, to file a petition for divorce. There are two things that you need to file for divorce in the state of Florida. One is jurisdiction. Jurisdiction is essentially a legalese fancy word for power. It's power of the court in order to make decisions off of your marriage, decisions on behalf of your children, decisions when it comes to dividing the property within the marriage. A second thing that needs to be proven to file for divorce in the state of Florida is that the marriage is irretrievably broken. Even though we are a no-fault state, the party that's filing or petitioning for divorce must let the court know that, look, my marriage is irretrievably broken. No type of counseling, no type of assistance can save my marriage. I'm ready to move forward with divorce. So those are the two primary things that need to be shown. And then I'll come back to jurisdiction, because jurisdiction tends to be an issue within the Muslim community when I go down that route. Typically, when people call, our office to have a consultation for a divorce, I give a general overview of the law, okay? Because we could be sitting here all night if I went through every detail and every aspect of divorce, which is why people hire attorneys, to make sure that we abide properly by the procedure and make it as smooth as possible. It's a very emotional time. We like to say family law attorneys deal with good people at the worst time of their lives. So there's a lot of emotions that go into it. I like to use an acronym called PEACE when I speak to people. So PEACE is the different types of issues that come up within divorce. You have the parenting plan, okay, the time sharing, the parental responsibility when it comes to the children that were born within the marriage. You have equitable distribution, any assets or liabilities that were acquired during the marriage, how we're going to divide them. Okay, you have alimony, which is spousal support. I know Amani was touching on that, the way that we see it in Islamic law, but there's a completely different standard and procedure in the state of Florida. You have C for child support, okay, the way that we calculate child support with the state of Florida. We have a very specific child support calculator based off of income and time sharing. And then E is everything else, which is a joke in the family law community between attorneys, which essentially means attorney's fees. Who's gonna pay the attorneys? Okay, so I'm gonna go through those processes. In the state of Florida, to file for a divorce, jurisdiction, like I stated, the way that you prove jurisdiction is that one of two of the parties have to have resided in the state of Florida for at least 6 months for the state of Florida to have power over that couple to actually grant them a divorce. The way that you prove jurisdiction, the easiest way, is by a driver's license or by a Florida ID. The judge will always ask to look at the final judgment hearing for that person's driver's license or ID and ask when it was issued. So it always has to be issued at least 6 months prior to the filing of divorce. If a person does not have ID, if they don't have a license, Another way to get around it is to file an affidavit of corroborating testimony, which is essentially another fancy term for somebody writing a letter on your behalf saying, hey, I know this person and I know that they've lived in Orlando, Florida for at least 1 year, and corroborating the fact that you live in the state of Florida. Once you establish jurisdiction, you file it within the county. Typically the county that you decide where to file for the divorce, and this becomes an issue too, because sometimes when people are separated, they'll leave the county where they resided in. But typically you must file for the county where the parties last intended to be married. Okay, so if the husband and the wife were married in Orlando, which is Orange County, that is typically where they will need to file for the divorce. Once you file that petition for divorce, you have to properly serve the other party. You have to serve the husband, which is typically, or the wife, with a process server. It typically, you give them 20 days and they have the right to respond to that answer. Now, when you're filing the petition, and the petition is basically your request to the court to say, look, my marriage is irretrievably broken. I've been separated from my spouse for X amount of time. And then you start pleading your request. So that's when the piece comes into sign. That's when the party starts requesting what they envision that they want for a parenting plan, what they envision, what they want for equitable distribution. They start listing their property, their assets. They start pleading, I would like alimony, I need spousal support, I've been dependent on my husband. I'm gonna keep it as, we're gonna say that the wife is the petitioner and that the husband is the respondent, okay? It's the Muslim Women's Organization. To be frank, most of my clients are women. I do, obviously still represent men, but most of my clients are women. So I'm gonna keep it like that just to avoid confusion. To have the wife be the petitioner, the one that's seeking for divorce. So within her petition, she's saying, I need child support, I'm in need, I have X amount of children with my husband, they're this age, we need to calculate child support, and then everything else. Okay, so that's the first step, is filing a petition. Typically, in situations to where the wife is dependent on the husband financially, we like to concurrently file something. And a lot of people, especially within our community, well, even outside of our community, they don't know that you can seek temporary relief. And temporary relief, when you file a motion with the court, a motion is another fancy word for a request to the court. You can ask the court for temporary relief, say, look, I'm going through a divorce. Sometimes a party can get divorced within 60 days. Other times divorces can take years, okay? And some women depend on the husband's financial support to be able to move forward, or they're seeking exclusive use and possession of the home. They want to remain in the home with the children. They want to maintain some type of stability for the kids. So they'll seek that at the same time that they file for divorce, well, the attorneys. You go into a hearing and the judge hopefully will grant some type of relief as throughout the pending of the proceedings until there's a final judgment or a settlement agreement. Now, a lot of confusion comes to our community based off of divorce because of a lot of what Amani was discussing with Islamic divorce, right? And Islamic divorce, it'll list out the type of rights that the woman has. So typically when, a Muslim, clientele or a woman that's recently migrated from a Muslim country, there's a lot of confusion. She's like, well, I'm entitled to the house. I'm entitled under Islam for alimony. My baby's only 1 year old. I'm entitled to have ultimate decision making. My baby needs to stay here. Why is he asking to see my baby? I'm entitled, to alimony, to spousal support. He needs to pay all of the bills for the house. He needs to pay my car. He needs to pay insurance. And then it's my duty, unfortunately, to advise her, like, look, I'm sorry, the law does not work that way, under the state of Florida. We can always, and I know Amani has actually been an expert in many cases within Florida for divorce law, but Islamic law, it's not mandatory for the judges to abide by it. We call it persuasive law. So if you have an expert like Amany that comes in and that can corroborate, the reasoning, then it's up to the judge's discretion to decide whether or not they will apply Islamic law. But in general, unfortunately, they do not. They'll abide by Florida statutory law. Okay, so that's the thing with Florida, is we really have to abide by the procedure and by the law. And unfortunately, a lot of our judges aren't very familiar with Islamic law or culture, or what unfortunately some of these women possibly go through. So that's just a very general overview of filing for divorce in the state of Florida. When it comes to a parenting plan in the state of Florida is typically, in the 90s, the early 2000s, they had this whole father's rights movements, because even, within American culture, when parties were getting separated, usually the children went to the mom. The dad was the primary breadwinner. He was always working. The mom was able to take care of the kids. She knew the routine. She knew their school schedule, their extracurriculars. So that was even common within American divorces. But in the early 2000s, they had this father's rights movement to where the court started shifting and saying, no, no, no. Fathers need to also be responsible, and they're also entitled to time sharing with their children as well. And it's very important for the children to maintain and strengthen their bond with their father, just as it is with their mother. So typically with the parenting plan, unless there's severe allegations of some type of abuse or neglect towards the children, not even towards the mother, because there are domestic violence situations to where the father will have no hostile contact. There's an injunction. He can't speak to the mother, but he's still entitled to some type of time sharing with the children, okay, unless there's severe allegations of abuse directly to the children. So generally speaking, there are two types of options when it comes to parental responsibility. The word custody, that's not a legal term that we use in Florida. We use time sharing. What's the time sharing that we're going to see with the children? It's typically 50-50. I really don't like the term 50-50 because you can't really divide 365 evenly between two. So it's really not 50-50. But generally speaking, that's what they like to give, because like I said, it's that maintaining and strengthening the bond of both the mother and the father with the children. So that's called 50-50 time sharing. You also have parental responsibility. Parental responsibility goes, who's going to make the decisions for the children? Who's going to make their healthcare decisions? Who's going to make their school decisions? Who's going to decide childcare on their behalf? Typically, the courts do like both parties to have that decision making, unless, like I said, there are severe allegations that the father should not be involved with the lives. Unless, of course, there's an emergency situation. If, God forbid, the children are with the mom and there's an emergency situation, she can make any type of decision and then reasonably reach out to the father. And like people, when I do these types of conversations, I consider this like my initial consultation, my initial dialogue I have with people that come to me. Like, you make it sound so simple and so easy, but it's obviously, this is just a general overview of the law. Equitable distribution. Florida is an equitable distribution state. This means that anything that was acquired during the marriage, assets, so any home that was purchased during the marriage, any vehicle that was purchased during the marriage, any type of money that was commingled within a checkings or savings account, any type of credit card debt, okay, because we're looking at assets and liabilities. So any type of credit card debt would fall into liabilities. Anything that was acquired during the marriage is split 50-50 between parties. A major issue that I see within the Muslim community is, unfortunately, when they get married overseas or even here, because with my marriage, I had an Islamic contract as well, okay? And then we sent it to the courthouse, and then we received our marriage license for the courthouse. So regardless of where they were getting married, if there's an Islamic contract, an issue that we see in dissolution of marriage is the husband is typically using that Islamic contract and saying that this is a prenuptial agreement. We don't need to abide by equitable distribution. When you signed this contract and we got married, your maher was actually the amount that you decided and said that this is what you were going to receive if we're divorced. So the house that we bought during the marriage, the cars that we bought during the marriage, any amount in the checking account, that's mine. You're only entitled to the maher. And unfortunately, it's 50-50 with somewhat of the judges decide. Okay, sometimes the judges decide, no, this is a marriage contract. This is what's used, with Muslim couples. Or some judges actually do agree and state that this is a prenuptial agreement and that the woman is only entitled to the amount of maher in equitable distribution. Okay, so obviously dependent on who we're representing is the type of argument. So if I'm representing the woman, I'm saying, no, this is just a contract that's typical of a Muslim couple. This is what they do. This isn't a maher. Just like Amani said, we would argue that she can pull that money or she can ask for that money at any time through the marriage. There's not a clear indicator that says this is her prenuptial, this is her prenuptial amount, this is what she's agreeing in case of divorce. While the husband is arguing that, no, this is a prenuptial agreement. The amount of money that you put is what you agreed to be given in case of divorce. Okay, so that's where it becomes a little weird with equitable distribution. And I see it a lot with Muslim, within the Muslim community. Okay, and unfortunately, a lot of women that come to me, they don't know their rights. You'll see it in the petition if the husband is filing for divorce. They'll just quickly put, there's a prenuptial agreement, the house is the husband's, the car is the husband, all the money in the bank account is the husband, the wife is entitled to nothing. And they don't know that they could try to argue it. So it depends on the argument, it depends on the discretion of the judge. That's why, myself, I actually just finished, get on a little soapbox, I just finished training to become a Florida court family law mediator. So inshallah, I actually finished the training yesterday. Inshallah, once everything clears with the Supreme Court, I'll be a mediator for family law cases by the beginning of next year. I always advise, because I'm a firm believer. I tell couples, I tell everyone, even when, I reach out to do a meet and confer with the other side, I'd prefer to settle this before going in front of a judge, because why would you want a judge to decide issues on your kids, issues on your home, personal issues within your marriage, right? It's better to try to come together. It's not that easy for all cases, but less than 3% of cases even go to trial. Typically, majority of divorce cases end up settling. It could take some time for them to enter a settlement agreement, but it does get very costly. It takes a lot of time. So I definitely try to encourage entering into some type of settlement and incorporating like Islamic law. Like, you should be in fear of God, and trying to persuade the other side, the husband, to try to abide by those concepts that his wife is familiar with. Alimony and petitions, I always plead for alimony. I don't care how long the marriage is. I don't care if they've only been married 6 months. Every petition of mine, I plead for alimony. Doesn't mean we're necessarily going to get it. No, because there's a lot of factors that go into alimony in the state of Florida. There's different types of alimony in the state of Florida. But alimony, the major factors of alimony is the length of marriage, how long they were married for. Okay, they look at, Florida divides it into 3 phases. You have a long-term marriage, which is more than 17 years in the state of Florida. Any marriage more than 17 years, I'm very confident that I'm going to receive some permanent alimony for my wife from the husband, as long as the husband has the ability and she has the need. You have a moderate, medium marriage, which is 8 to 16 years. And then you have a short-term marriage between 1 to 7 years, okay? There's different types of alimony. You have rehabilitative alimony, which is Let's give, the wife some type of money to get back onto her feet. If she needs to go back to school to obtain some type of degree, to attain some type of specialized skill certificate, let's give her a lump sum amount of money to go back to it. Bridge the Gap is very similar to that as well, but Bridge the Gap has a time limit. It can't be for longer than 2 years, to give her some type of monthly financial support to get back on her feet because of the shock of divorce. Permanent alimony, like I said, permanent alimony is typically given for long-term marriages or when the wife has some type of mental health disability or physical disability to where she's unable to go and work, so that the husband, would be financially responsible for her. But there are a lot of factors that go into alimony as well. Child support. Child support in the state of Florida, every family law attorney, we have this software to where it's based off a variety of factors. You look at the time sharing. You can't really calculate child support until you figure out the time sharing with the children, because you have to calculate the amount of overnights that each party has. So that's one factor of child support. Another factor of child support is who's paying for health insurance, who's paying for child care, okay? The financial responsibility, who's been maintaining the financial responsibility for the kids. That's thrown into the calculation. The third and biggest thing that's thrown into the calculation is the income of the parties. How much is mom making? How much is dad making? So we throw all those factors into a software and it'll calculate the amount of money that each party is required to pay for their children and child support. So there's not really much, unless the parties agree to a particular amount of child support, that I can do as a family law attorney with child support, because those factors are thrown in to what we call the child support calculator. I know that you could even Google Florida child support calculator and play with it and throw some of the factors in just to get a general overview of the amount of money, but child support, that's how we calculate it within the state of Florida. Now, some common issues that I see specific, to the Muslim community. I have been doing this for quite some time, for several years. It'll be 9 years in April, specific to family law. I do also practice immigration. I actually started off with immigration, but now I've been so busy with divorce and family law, I've kind of shifted towards family law, but I'm really grateful and appreciative of my immigration background, because there's a lot of issues that intersect within family law, especially within our community with immigration and with family law. A huge issue that I see is a language barrier, okay? Unfortunately, in family law, which I feel like we need to petition to the Supreme Court and we need to have our laws changed, a person is not entitled to interpreter. So dependent on, the economic status of the wife, she either has to try to bring in a friend, which a lot of them are hesitant to because they don't want their friends to know these intimate details of their marriage and what they're truly going to, or their family members, because a lot of them tend to keep the details of what was going on within their marriage away. They would have to pay, for an interpreter. You're not providing an interpreter at any part of the family law situation. Immigration issues, you see a lot of the husbands using immigration as a manipulative and controlling tool to the wife, saying, you can't divorce me, you're going to lose your papers. You depend on me, but there are realms and there are remedies for immigration. Sometimes with undocumented parties, they fear that because they're undocumented, they're not able to even file for divorce and to receive any remedy. Family law courts, they do not care about your immigration status. Like I said, their primary concern is jurisdiction. And if you and your children have lived within the state of Florida for at least 6 months. Okay, so if they're undocumented, and I've represented quite a few, they're undocumented, they don't have a valid license, they don't have a valid ID, but they can get someone to corroborate and say that I've known this person, I've known that they've lived at this address for XYZ, and that gets us through that jurisdiction and residential requirement for the state of Florida. You also have, unfortunately, when immigration papers are pending, a woman is scared to file for divorce because, you know, she's dependent, she's a beneficiary of her husband, and she's thinking that, okay, because my husband filed for me, I have to maintain myself within this relationship and have a good faith marriage to go in front of immigration to receive my green card. Or she might have a conditional green card and she needs to maintain that good faith relationship with her husband to wait to get her permanent 10-year green card, is what a lot of people like to say. Within our community, but there are outlets and there are protections. You have the Violence Against Women Act, okay, that protects domestic violence. I don't say victims, I always say survivors. I never say domestic violence victims. I think that if someone's gone through that and they're trying to get out of it, they're survivors. So you will never hear me say a victim. So that's an outlet that can help. With the removal of conditions, there's waivers that can be done if you're going through a divorce and your divorce is finalized, or if you can prove some type of abuse that can protect a woman. So there are outlets. There's a U visa, to where, unfortunately, in extreme situations, okay, where I know Michelle's nodding her head because she works with domestic violence, so this is all very familiar to her. The U visa, if there's a severe, you know, situation with domestic violence and the wife participates, you know, in the criminal court proceedings of the husband, there is a remedy through immigration to provide her with some type of visa. So there are remedies. The problem is that without resources like the MWO or advocates within the community, these women are unaware, right? Because a lot of them are isolated. That's another thing. I get several calls per week of women just crying to me saying, I came to this country, I have nobody, my family's overseas, what am I gonna do? He isolated me, I don't have friends, I don't know the law. They don't want to tell their family overseas what's happening. If they do tell them what's happening, they're not telling them the entire story because they don't want them to worry. So there's a lot of factors that are thrown in. Unfortunately, domestic violence, you know, within our community, domestic violence is just a whole other realm. And I know the MWO is great and provides a lot of resources for our survivors out there. But with domestic violence, there are many issues that come in. When it pertains to divorce directly, domestic violence will come into play. Like I said, Florida is a no-fault state, but if there are allegations of domestic violence or if there's a criminal court case proceeding, you better believe that myself as an attorney am going to put that in the petition. I am going to put that in the motion for temporary relief to try to give my wife's my client some type of relief, at least throughout the proceedings, right? I want to let the judge know you can't unring the bell. So I want to let the judge know, you know, who we're dealing with, who the husband is, and plead it. So a judge does have a wide variety of discretion when it comes to the divorce, or it's important for a mediator in the state of Florida. Mediation is required in every dissolution of marriage. Okay, before you can go in front of a judge for a trial, you are required to go to mediation. So it's important for the mediator to even know that there's domestic violence issues to keep them separated. Now, most of our mediations, they're done on Zoom, right? But there's ways to keep them separate, keep them each in their own breakout room so that they don't have to see each other face to face, or if there is some type of injunction or no contact order. Another a conflict with Islamic law. I kind of already touched on this, but this tends to be, you know, one of the hardest things for me as the attorney to explain to a wife that comes to me. Well, in my country, I'm entitled to X, Y, Z. So for me to kind of, you know, say, okay, well, we can try to argue that, we can try to settle that with the husband or with his attorney, but my job is to kind of manage your expectations and convey the law to you and let you know that this is unfortunately the way that it works within Florida law, who has jurisdiction over your divorce. I don't know if anyone has any questions for me so far. Like I said, I wanted to keep this more so conversational typically if someone calls me, I give them the general overview of the law, and then I'll take, the facts from them and answer any questions. So if anyone has any questions for me, please don't hesitate to chime in. Or Amani, I know me and Amani and Michelle, we discussed, this last Thursday. If you have anything to throw in there and want me to emphasize on, I'm more than happy to.
I have a question. So because you were talking about how the Islamic contract for marriage is being used like as a prenup in the courts. So it's kind of being used against women. And particularly like if, for example, somebody has gotten married in another country, right? And so I'm wondering, have you ever experienced that being used maybe as a benefit? So for example, like if you have a client who did get married overseas and you have this contract, and then you say, and you go to court and you say, have an expert witness, for example, like Amani, and you say, well, Islamically, this woman would be entitled to the house, this much, exclusive rights to the children, et cetera, et cetera. And because they got married in this country, it's
absolutely. And that's the primary argument, right, for the wife. So the husband's argument is to use it against her, to use it as a prenuptial agreement. And I've definitely used it. It hasn't reached to the point of getting to the judge to decide. And that's the reason I love mediation. I've actually taken the additional step to be a mediator, because you can hash out a lot of things and you can speak confidentiality. So I've used it as something in addition to her getting. So there is equitable distribution, but actually, according to this Islamic contract, you owe her X amount of money in addition to the equitable distribution. And that's what she's entitled to, right? So that's my side of the argument 100%, if I'm representing the wife.
Perfect. Has that been effective?
Yes, it has worked. And sometimes the men say, I fear God, I'm religious, I want to give her what she's owed, under Islam, give her this. So obviously in highly contentious cases, that's where we have the problem and the arguments, and where we need experts like Amani to come in. And typically these people have money to afford experts, to afford going into trial, right? But majority of cases, unfortunately, are not like that. So I tend to use, I'm like, you have daughters, aren't you scared? Because I can say things like that in mediation that I wouldn't be able to say in front of a judge. So those are, kind of my creative lawyering skills.
Okay. I do have to say also that as Gigi was saying, it is left to the judge discretion. So for example, I was testifying in a case where the judge, the opponent kind of attorney for the husband, she actually argued that it is not an Islamic law. It is not an Islamic contract. It's a Jordanian contract, for example. And so it was hard for the judge to understand, even though it says Sharia law on the contract, or المحكمة الشرعية, the court, the Islamic court, the judge couldn't understand that. And he's like, yeah, it's a Jordanian law. And the wife lost the case. So it is really very tricky. I think if you can't do mediation, which is better, as Gigi said, so the woman can get all of these rights, then you're left to go to the court and decide. And the only other case that the marriage contract can be in favor of the wife, if she done it here in the United States, and if it is also stipulated the mahr that is in dollars, and it is a reasonable amount. That's why I encourage women who marry here to not do the marriage overseas, to if they are living here already, to do the marriage here and to be careful and understanding of these issues, so they can really protect their rights.
Absolutely. And another thing, is to have access to the contract, to have access to the papers, right? That's another issue, is unfortunate law of the woman, they don't have access to these significant documents. The husband is holding on to them. So if you do enter that type of contract, or you do have have a copy, protect yourself, always have them be accessible to you. I see Yasmin wrote a question about simplified dissolution of marriage. That's an excellent.
I'm sorry, I want to stop you for just 1 second. I think I just want to let everybody know, we're gonna turn off the recording right now so that people feel more comfortable asking questions. But I just wanted to make that announcement, but go ahead and answer that question, please.